Hello everyone, this is Matt with Learn About Law, and in this video we will discuss what is needed for a valid contract in Wisconsin, including, does a contract need to be in writing? What about oral contracts? What can be used as evidence that a valid contract exists? And what are the requirements for a valid contract? So, let's get started. Some contracts require a writing to be enforceable. Real estate agreements or agreements conveying real property generally require a writing. Agreements that will not be completed within a year and promises to answer for the debt of another are examples of contracts that definitely should be in writing. Generally, if a writing is required, both parties need to sign for the contract to be valid and enforceable. What about oral contracts? Many contracts do not require writing or signatures to be valid. Courts can look at the parties' conduct or evidence of the parties' intent to determine if there was, in fact, a valid agreement between the parties. Oral contracts could be for bartering, services or goods, or lease agreements. So, what can be used as evidence that a valid contract exists? With oral contracts, evidence of the parties' conduct or intent can generally be used to determine whether or not a valid contract exists, or what the terms of that contract are. Written agreements are a little more complicated. The parole evidence rule is a doctrine that applies to written contracts. The rule basically means that when there is a written agreement, no outside evidence should be used to determine what the parties agreed to. The agreement should be completely integrated, meaning the parties intended that it be final and complete, and that there are no missing or ambiguous terms. If a contract is incomplete and missing essential terms, there may be no valid contract at all. What are the general requirements for a valid contract? While some contracts require a writing, as discussed above, the fundamental principles required for a valid contract are the offer, an acceptance, and consideration. An offer needs to be addressed to a specific person who must understand it as an offer and have the capacity to accept it. An offer must be definite in its terms, so that it is clear whether or not the agreement has been kept or broken. An offer must, once accepted, bind the offerer such that there is a valid and enforceable contract. There are many ways to accept an offer. One being both parties signing an agreement, the second being accepted verbally, and third being accepted by conduct. Lastly, what is consideration? Well, something of value must be exchanged. If only one party is giving up something of value, then it is likely a gift, not a contract. Thanks for watching. For more information, check out our article links below and be sure to leave any questions you have in the comments and subscribe for more legal content daily.